Welcome to Rightly Decided, the mostly originalist takes of the litigators of the Texas Public Policy Foundation. I'm Laura Beth Latimer, and I'm here with attorney Nathan Seltzer and our director of litigation, Chance Weldon. And we're bringing you Supreme Court cases as they drop this session. Today we're going to talk a little bit about Danco versus Louisiana, which is the Mifepristone case that dropped has been in the process of dropping for a while now, let's be honest. Before we get into this, I do want to start with a little bit of a disclaimer, which is that we're going to be talking about, obviously, Mifepristone and abortion and sort of the related cultural issues that underlie this are not really the point of this podcast. We all have our positions and feelings about abortion, and you're not going to hear them here, and that's important because we're here to talk about the law and the way that this case shakes out in the middle of our jurisprudence, particularly around, drum roll please, standing. We want to talk about, want is a strong word. We're going to talk about standing. We must. Our needs must to talk about standing today. So 10,000 foot view. Chance, will you just give us a little bit of an overview of how we got here in Danco versus Louisiana?
So for everyone who's not familiar, Mifepristone is Mifepristone.
Mifepristone.
Am I saying that correctly?
Mifepristone, yeah.
There are a lot of consonants in a row in that word, so it's difficult to say. I think we had AI read it this morning, Mifepristone.
And she tried to say it Mifepristone, and that was a no. We're not saying it that way.
So Mifepristone is an abortion-inducing drug. And so how we got here was, when the Supreme Court overturned Roe in Dobbs, the Biden administration at that time announced that they were going to do everything possible to circumvent that opinion. And
what was that language? Pull every lever. We're going to pull every lever
in order to circumvent that opinion so that they could make sure that people were still able to get abortions, even in states perhaps that were restricting abortion in the wake of Dobbs.
So Dobbs drops like right before the summer of 2022.
Yeah.
Okay.
I think it's important to point out, too, for those who didn't follow the Dobbs debacle, if you will, all that Dobbs really did was say that states can decide whether or not they're going to restrict abortions, whether or not they're going to prohibit abortions. Yes.
Yeah, the people.
Right, the people. Return it to the people is the language. So in the wake of Dobbs, many states did, in fact, start prohibiting abortion.
Right. And so the Biden administration decided that it was going to pull every regulatory lever that it had to allow people to still get abortions in those states. And one of the ways that they did that was to change the regulations involving the sale of Mifepristone across state lines, in particular, not requiring an in-person doctor appointment to get Mifepristone. And so the idea being that, some doctor or someone in New York could ship Mifepristone to someone in, say, Louisiana, where abortion was restricted or Mifepristone was restricted. And so originally, several doctors challenged this case. This may sound very familiar. Several doctors challenged that deregulatory effort, and they took it to the Supreme Court, and the Supreme Court held 9-0 that they did not have standing, that they had not shown that they were injured because they were actually trying to get the government to regulate someone else, and there were too many steps in between the government action and any injury that they had suffered.
And so we'll talk more a little bit later on about that specific case and how that plays into this regulatory function. So then we come to...
Well, importantly, though, in that case, which the Alliance for Hippocratic Medicine case, is they did not reach the merits of whether or not the FDA was correct or incorrect in actually instituting that new regulation.
Yeah. So. And so it's important to remember to that point is, the administration has now admitted that it didn't follow the regulatory steps to deregulate Mifepristone. So under the Administrative Procedures Act, under the regulations dealing with the FDA, for FDA regulations, there are certain sort of procedural mechanisms that you have to go through. And at this point, it's pretty clear that they didn't go through those. They were just trying to shortcut and get this out as quickly as possible as part of this push to circumvent state regulations on abortion. And so that's sort of at this point undisputed in this case. And so the question becomes, if the doctors couldn't sue, who could sue? So the state of Louisiana sues, and their argument is effectively that if the federal government is not regulating Mifepristone, if it's not prohibiting Mifepristone, it's going to undercut their ability to prohibit or regulate Mifepristone because people will be shipping these drugs in from other states. And they say that that's an injury to get into court, and that's an injury sufficient for them to have standing. And that's what gets us to the Fifth Circuit's opinion in this case. Fifth Circuit finds that they have standing, unlike the doctors, and then declares the deregulatory effort unlawful, and it issues a stay of that rule, which is under the APA. You can stay rules. It's kind of like an injunction, but not. It basically says that the rule doesn't go into effect. And then Danco, which is the manufacturer of the drug, they run up to the Supreme Court asking for a stay of that stay so they can continue to sell the drug. And
under the new regulatory framework. So there's also not a prohibition on Danco selling this drug. It's just, can Danco sell this drug under the new regulatory framework, or does it have to play under the old regulatory framework? Okay.
Yes.
So we're looking for a stay of the Fifth Circuit stay. Mm-hmm. And the question that every attorney who works in this field of law has, and almost no one else in the rest of America, is, do they actually have standing to continue pursuing this? Does Louisiana have standing to continue pursuing this lawsuit?
Well, so I think that's the question we think the court's deciding. It's important to point out is that the court grants the stay of the stay, but because it happens on the shadow docket, we don't know exactly how the votes broke down, except that we know that they had 5 to grant the stay. We don't know which justices they were. And we know that both Thomas and Alito are in dissent. They would have not granted the stay for reasons we can talk about later.
And there's something that happened leading up to this in the run-up where Justice Alito, although he dissents from the stay later, actually was the one who initially granted the stay. So for those of us who didn't go to law school, who are listening to this podcast, what's the process by which a single justice decides something, and then is he bound by that? Obviously, Justice Alito wasn't bound by that decision later on. He dissented from the stay in the long run. How does that work?
So each circuit has a justice assigned to it. So like the Fifth Circuit that sits in New Orleans, there's a Supreme Court justice that's assigned to hear emergency petitions coming from that court. So when you have something that's outside of the regular order, there's an emergency petition to stay something, it goes to that justice. Now, in a lot of cases, going back for forever, a single justice can sometimes just resolve that, what they call in chambers, on their own. They're like, this isn't sufficient to even share with my colleagues. There's a lot of frivolous appeals that run up to the Supreme Court. Right. The other thing that the justice can do is he can actually circulate it to the other colleagues to actually say, hey, we all need to look at this. This might have something worth looking at. And he can administratively stay the lower court opinion while the court has a chance to take a look at it. So this is basically saying, hey, pump the brakes on this Fifth Circuit opinion for a few weeks while we can look at it and decide whether or not we're going to stay it for the duration of the litigation.
So when we say stay, we're talking about basically a pause of whatever is about to happen.
Yeah.
So it's by definition, it's going to be a temporary halt. And so like that's what our temporary pause. And that's what's happened here. We have a temporary pause. So no matter what happens going forward, this isn't the final judgment of the Supreme Court, or this isn't the final judgment in the case, certainly.
And you could think about it like with a death penalty appeal, right? Something comes up at the 11th hour, it goes to the circuit justice and he says, oh, this seems like there's something here that we all need to consider. You can't let the guy get executed while you're reading the briefs, right? It's going to take time for the court to read the briefs. Yeah. And so in that sort of situation, the circuit justice is going to grant an administrative stay so the full court can hear about it.
And so in this case, all of those headlines from 2 weeks ago that were saying, Justice Alito grants the stay in spite of Dobbs, and all of the hair on fire reporting was really just Justice Alito saying, hold on, I need a few days to get this to the other members of the court, and then we'll decide on the underlying merits of the stay. And merits of the stay.
Merits of the stay of the stay.
Of the stay of the stay. Yeah, but not the merits of the issue, just the stay. Yeah. Anyway, so all that to say, the underlying question that we as attorneys have, again, that the court is not actually deciding or speaking on here, is this interesting issue of standing. Yeah. Does a state have standing to sue the federal government in hopes of the federal government regulating, either to force them to regulate or to nudge them to regulate, which is kind of suggested in what Justice Alito says. Right. Does the state actually have standing to do that? So I'd like to rewind our clock a little bit, all the way. Well, we can start at the general premise, I suppose. What is the general rule of standing? Like, if we were just to say in general terms, what is the most obvious type of standing for individuals who want to sue the government?
Okay, so Article 3 of the Constitution, which creates the federal court system, gives the federal courts authority to decide cases or controversies. They can't just decide any sort of public dispute that they want to weigh in on. There can't just be a piece of legislation and the court says, oh, unconstitutional. There have to be parties, and those parties have to have something that at the common law would have been considered a case or controversy. And what this ordinarily means is they have to be injured in some sort of unique way that's distinct from the population as a whole, and an injury that can be resolved by some sort of judicial relief. So for lawyers, that's usually 3 factors. You have to be injured, it has to be traceable to the action that you challenge, and it has to be redressable by some sort of court order, right? And so that's what standing is. Now, for most of the work that we do, it's pretty straightforward. If you are regulated by the government, like the government says, hey, you can't go to church on Sundays, that's an injury in fact. It's traceable to that regulation that you're challenging. And then the court would just tell the local government not to enforce that regulation. That would be the injunction that the court would issue. It gets a little bit more weird, though, when you're asking the government, you're saying that you've been injured by the government's failure to regulate something.
And before we get there, let's drill down a little bit on that concept of being injured by a regulation. So it's not this, I'm injured because the government puts this regulation out. We'll say for just this purpose that it's an executive order that says no one's allowed to go to church.
Yeah.
Not only am I injured if I go to church and then I'm arrested and then I sue the government, but also I know that if I go to church, I'm going to be arrested. And therefore I'm not going to go to church, which means that I wasn't able to go to church. And that's my injury. That's the injury, in fact, that we're usually talking about when we talk about what we would call in the Fifth Circuit contender farm standing. That as a regulated party, I'm actively making a decision not to violate the law because I'm a responsible person, a member of society that's trying to abide by the laws, and therefore the existence of that regulation is actually causing me an injury.
Right. So in this case, the regulated party is Danco. They're the manufacturer, and they're attempting to distribute Mifepristone. And so, but like Louisiana is not regulated, and then the regulator here is the FDA. They're the ones saying what Danco can and can't do and how they can go about it. And so Danco would clearly have standing, I think, for the purposes of this.
So we would ordinarily expect to see a lawsuit where Danco sues the FDA and says, hey, I don't like the way that you're regulating Mifepristone. But that's not what happened here. And that's where we get to the interesting question that presents in Massachusetts versus EPA, fast forwarding a little bit to 2007.
Yeah, so historically, standing is typically, in most cases, you're the regulated party. There's some other ways that you can get standing, but it's really hard. It's really hard. You have to really tie together the causation and the injury, in fact. That changes a little bit with a case called Massachusetts versus EPA. And there, the state of Massachusetts sued to force the federal government to do more to regulate greenhouse gases. Right? So they weren't trying to get rid of a regulation. They're trying to force the government to regulate more because of climate change. And their theory of the case is if you don't do more to regulate climate change, the sea levels are going to rise at some indefinite point in the future, and that's going to swallow up some of Massachusetts coastline, and as a result, we'll have standing. Now, we'll have an injury.
We'll have an injury because now, as a state, our coastline is gone, which hurts us.
Right.
But that might be 100 years from now. It might be 20 years from now. We can't really say when, but that's,
And so,
but the damage is accruing now. Under their theory, the damage has started to happen now, and it's like accruing over time or whatever.
And so ordinarily, if they were an individual who brought a claim like that, the same thing would have happened as when the doctors, for example, in the Mifepristone case sued, and the court said they didn't have standing because there were too many degrees of separation from the lack of regulation to an injury, right? And so ordinarily, if you had something that speculative, you're asking the government to regulate, the court is trying to force the government to regulate, they wouldn't have had standing. But in Massachusetts versus EPA, 5-4, the court creates a new type of standing where they say, well, states aren't like ordinary litigants. And we have something called special solicitude for the states.
What a word, solicitude.
Yeah, and it's really sort of a thumb on the scale that, the state, has special kinds of injuries, and we're going to respect them more when they want to come into federal court as a party.
So is this stemming from that mentality that I tend to think of as more progressive, I mean, in a technical way, more progressive mentality, that the government stands as like a parent figure over all of its citizens? It's sort of it's the parens patriae kind of concept. Is that where this comes from, or is it different from that?
Well, it's a little bit unclear where it comes from in Massachusetts versus EPA. Nathan, do you have thoughts on where it comes from?
Well, I mean, you can go back where when in the progressive era, I'm just going to go back to 1907, that there was a Supreme Court opinion that talks about that it sort of has this theory of state government power that it's unlimited. And so if the land in Massachusetts is harmed, then Massachusetts has sort of this quasi sovereign interest in the land and in the people, and it would be able to Massachusetts would be able to do anything it wanted with that land, and so it has an interest in anything happening to the coast eroding or something like that.
I think this is a really important point as well. I think, Nathan, you're the one who brought this up when we were talking about this beforehand, that Massachusetts is unique in that the state itself does not own the coastlines. Like in the state of Texas and I think the state of Florida, the state itself owns the coast, but Massachusetts is not that way. Is that correct?
I don't know the question about whether or not the beaches themselves are owned, like Texas has the Open Beaches Act.
Yeah.
But I know that the underwater portion of Massachusetts coastline is Massachusetts land all the way out to the outer continental shelf. So if the coastline did erode, Massachusetts would be gaining land. So we can talk about that.
The state of Massachusetts would certainly be growing and not shrinking. So Massachusetts itself doesn't have an injury in fact, in the sense that, like in Texas, the state could claim, well, our beaches are going away, and so our tourism dollars are following it, and that is an injury in fact. But here, this is not the same. It's not the same question.
But it's an injury in fact that typically before Massachusetts v. EPA would not have been, fancy word, judicially cognizable, right? It's not something that the courts usually do because of separation of powers. And if you think about it, ordinarily when you go to court, you can get an injunction that tells like the executive branch to not enforce something, like, or to let me out of jail, or to give me my property back, or to stop enforcing. That's something that judges ordinarily issue. Judges don't ordinarily issue an order saying, write a specific regulation.
Right.
Or regulate this way. Or the court doesn't typically write out the regulation for the government, because that's not what courts do. Typically, if the court's going to make the government do something, that would be something called mandamus. And mandamus is only for purely ministerial things, right? So if there's something that the government has to do under a statute, the court can say fulfill the statutory duty. But if the government has any sort of discretion, typically a court can't force them to do something that's discretionary, like pass legislation. That's a real separation of powers issue. And
it's easy, I think, to fall into a sort of a trap of believing that just because Congress has instructed an agency to do something does not mean that they have a ministerial duty to do that thing. So Congress says, FDA, regulate these drugs. That does not all of a sudden give a ministerial duty in the sense that it could be sued over for the agency to actually do that regulation of those drugs, for example.
The specific kind of regulate.
Right. That there is still discretion within that function of enforcement. And there's almost always discretion in that function of enforcement as well as in the function of regulation itself.
But we're not even into the enforcement of the regulations, though. This is just creating these regulations. This is like the court telling the agency, okay, you need to create a new regulation and then you need to enforce it. We kind of agree, like in prosecutorial discretion areas, which you know much more about than I do, that the court can't even tell a district attorney to prosecute a certain individual or to prosecute a certain statute more vigorously than they are doing so, because there's an area of executive function that courts understand that they can't command the executive to do those sorts of things. But we can't even get that part, because it's almost like the court would have to create the standard which needs to be enforced first, and that's also not the court's function. So we're like a couple steps away from the area where you're talking about.
Right. But that's exactly where we land in Mass v. EPA.
Yeah. So that's what happens in Mass v. EPA. And so I think it's important to think about the theory that Louisiana has in this case. So Louisiana's theory here is not about global warming. It's about, we have prohibited something and other states have not prohibited this thing. And so federal government, we need you to prohibit this thing so that we can better enforce our law. Now, that's a unique theory of injury for standing purposes. And you can imagine if the state of California has all sorts of stuff that it prohibits that the state of Texas doesn't. And so this theory of standing that Louisiana has put forward would allow, say, for example, the state of California to come into federal court in the Ninth Circuit and say, we need the federal government to write new regulations, to do more regulatory actions, because Texas doesn't prohibit the things that California does. And that's just, I think, a really unique theory of standing.
I think when I was in high school, I think, when Colorado passed its amendment legalizing marijuana, there was conversations from the surrounding states about, hey, we need to sue Colorado or sue and sue the federal government because Colorado's distributors are now shipping into our states. So Utah and Montana and all of these states in the West were saying, we don't want Colorado's marijuana, so we're going to ask the federal government to enforce their marijuana regulations that were already on the books. So we're sort of in a different sort of territory here. But to force the federal government to enforce its prohibition on marijuana in Colorado because we don't want that marijuana to be shipped to us. Right. And I don't think that was ever sued on. I wasn't able to find it. But I remember that conversation happening at the time that was the federal government should be forced by the surrounding states to enforce its law here. Yeah. And that's the same basic concept. It's just kind of the flip side of the same coin, right? Which one do we like and which one do we not like from a cultural standpoint?
Yeah, and I think it's interesting, these are hard questions because you look at what happened in this particular case, and this is something that happened in the Biden administration a lot. There's no dispute now at this point. This goes to like Alito's dissent. So Alito talks about this in his dissent. The FDA has now admitted that it didn't follow the process for Mifepristone because it didn't consider, the
patient safety.
Patient safety of all things.
It didn't consider patient safety, and it's the FDA. And so what you really have here is a situation where the government sort of admitted that it violated the procedural law. We saw this a lot with, the Biden administration when it had something that it wanted to do, like with our clients in the Vineyard Wind program, where you had offshore wind farms. And if you had wanted to do anything else on the outer continental shelf, if you want to do an oil platform, if you wanted to do anything else, there'd be all of this bureaucratic box checking that you had to do. But then when it came to something that the Biden administration wanted to push through, like wind farms, they didn't do any of that. And so you had like wind turbines collapsing into the ocean because they wanted to circumvent these processes. And then it just becomes hard to figure out who has standing to sue over that.
Which is not to say that we're standing here advocating for more bureaucracy. That's not what's happening. It's play by the rules that you've instituted.
Right.
Whereas what the Biden administration was doing was cutting every corner. By pull every lever, they would cut every corner. It was that we don't care about the processes that we've put in place or how important they are. Like, for example, consider for a minute patient safety when you're creating a regulation designed to help patients be more safe and healthy.
Yeah. Arguably the entire purpose of the FDA, right, is to protect people from unsafe drugs. Like, we can at least agree that that's the goal of the FDA.
That's the idea.
If there's any goal.
If there's a goal here at all. So when we get to, from a standing perspective, Alliance for Hippocratic Medicine, which is the first Mifepristone case, what is the difference other than this kind of special solicitude between the doctors? And we didn't really go into this. The doctor's theory of standing was a group of pro-life physicians were asking the federal government to create regulations surrounding Mifepristone because they did not want to be in an emergency room situation and be the only doctor who's on call when someone has a life-threatening injury caused by Mifepristone that was prescribed by an out-of-state doctor. So there's like 9 different degrees of removal from the injury itself, but that's a very similar level of separation to what we see the state of Louisiana having in the causation in this case. Well, what's the difference and why?
So I think it's important to explain, I think, to the non-lawyers whose brain hasn't been warped by law school of why that's not an injury for standing purposes, or just with the doctors, right?
Right,
that
sort of start there. Why is that
chain
not
of
an
consequences.
injury?
So if you think about, let's say that you don't like the speed limit. You think the speed limit on the highways in Texas should be lower. Now, ordinarily, the way that you would fix that is you would go to the legislature and you would ask the legislature to lower the speed limit. You wouldn't say that, I'm injured by the higher speed limit because there's a chance that somebody might be driving too fast and hit me on Tuesday, and therefore I have an injury in fact that gets me into court, hypothetically, to sue to get the court to judicially lower the speed limit. That is not something that you would ordinarily see in court. That's not telling the government to stop regulating you. It's telling the government to regulate someone else because some chain of consequences might conceivably result in some injury for you.
And that's like when we talked about stays, we kind of made some jokes about stays earlier, and that the court's saying stop this, and then no, stop the stopping of the stay. But like that's what courts traditionally, like their power is used to stop the government from doing something. If you're going to get an injunction, and you went over that there's a few narrow situations where you can tell the government, okay, you must do this, but that's more like granting a permit. Like you have to grant this permit. But something like changing the speed limit is not something that's within the power of the government. They can say stop. Yeah. But they can't stop government doing something that's violating someone's rights or that you don't have the power to do.
Right. The judiciary is not designed to create rules. The judiciary is designed to remove rules that are there unconstitutionally and also to enforce the rules that we currently have. Yeah. They're not designed to put a new positive obligation upon the government. And on that note, I think it's worth talking about, we haven't really gone into this a whole lot on the podcast, but like what causes that? What causes the shift in that mentality that now, instead of going to my legislature, my first knee-jerk instinct is to go to the judiciary to solve my problems?
This is so much of a Congress do your job.
This is so much of a Congress do your job thing.
People have just given up on doing things through the legislative process. And this has been a long-running thing across administrations. Both sides have been guilty of it. You know, it started, with Woodrow Wilson and then FDR, and then over time, things get pushed into the executive branch. And, as gridlock gets worse, people just don't believe in the legislative process. They want to do everything through executive action. And so, that's what you see here on both sides. And I think there's a frustration that you can see from folks like Justice Alito in this case, where it's like, we know that what the agency did here was unlawful.
Yeah.
I think there's a big difference, but just going back to the Massachusetts v. EPA problem, there's a difference between like the executive does something because Congress is sort of delegated an authority or arguably is delegated an authority. And so the court's saying, no, you can't do that. No, you can't do that. But that's different than saying you must do this thing. And so that's where the Massachusetts v. EPA is very different from, I mean, this is obviously that was 2007. That was not the first time that a court told the executive branch you can't do that.
Right.
That goes way back. But it was maybe the first time or one of the first times that we can find of them saying, okay, executive branch, you must do this new thing that we've generated. Yeah. That's very different.
So let's jump. You just brought up Justice Alito's dissent in this a little bit. Let's jump to Justice Alito's dissent. Nathan, what does Justice Alito say here? Why does he dissent from this?
So, I mean, ultimately what he says is that there's not sort of the irreparable injury that's necessary to get a stay. And so it's a very narrow decision, but he marches through and it's worth talking about. He marches through Louisiana's argument for why they need this executive action by the FDA paused. So he marches through there, and it basically seems to agree with, or at least recounts sort of their argument that what Chance discussed, that the people in Louisiana are being harmed by Mifepristone being shipped in illegally against Louisiana law by other states, and that it would be better for Louisiana, it would be easier for them to enforce their law if the FDA went back to its previous regulations that were more strict on in-person dispensing requirements. So no one's saying that Mifepristone should be completely banned in this case. They're just saying that the in-person dispensing requirements, which is what used to be in place before 2023, that those should be restored. He does mention that that was not actually being enforced before 20. So as going back a couple years, the FDA, even though they had an in-person dispensing requirement, they were not enforcing the in-person dispensing requirement. That's actually a problem for Louisiana because it seems to be that Louisiana would not have standing because nothing changes. If you go back to the old requirements that weren't being enforced, how is that any different than the new requirements?
So you just have a straight up redressability problem. We can go back to exactly the same way it was before, but it doesn't solve your problem at all, Louisiana.
Yeah. But that's all that's all goes into the who's going to ultimately prevail in this action. But for the purposes of the stay, Louisiana is. So who's asking for the stay now? Louisiana.
Danco's
asking for the stay.
Thank you. So Danco
of
is
the
asking
stay that
for
was
the
requested by Louisiana.
And so Justice Alito makes the point that Danco, in asking for the stay, is they're asking for it to go back to a situation that was the same before this action. So they're asking, like, don't hurt us anymore, is what Danco is saying. Please stop this. Don't hurt us anymore. And Justice Alito saying it's exactly the same situation as it was on the ground before the Fifth Circuit issued its stay. And so it's you have like a stay of a stay, and what Justice Alito is saying is this is really simple. Danco's not being irreparably harmed here.
Can we unpack that a little bit procedurally? So to get into court, when you're suing, when you're the one wanting the government to do something, you have to show that you're injured by the thing you're challenging and that you want a judgment on that. Now, let's say the court rules for you, right? And it tells the government, stop doing this or do this. The court has given you the relief.
You've gotten the order. Okay.
Okay. Well, then the government can run up on appeal and seek a stay of that order.
Right.
But when they're seeking a stay, they have to show now that they are injured by the judgment below, right? So they have to show, like, I have an irreparable injury that's being caused by this judgment. And therefore, while the thing goes up through appeal, this court should stop the lower court's judgment from going into effect. That's what they're basically saying. They're going out of the ordinary course, out of the ordinary procedure, and saying that, like, look, if you don't do something, court, I'm going to suffer irreparable harms. And that has to be shown before a court can grant a stay while the case proceeds.
And this one's a little funky because while it is the FDA that is the defendant in this, Danco is what we call a defendant intervener, which means that when Louisiana sued, they only sued the FDA, and Danco came in and was like, wait, we need to be part of this too. Excuse us. This is our, it's all about us. We have an interest here that needs to be defended. So even though it is the stay of the rule, is the stay of the FDA's rule, Danco is coming in as a defendant intervener on behalf of the FDA, really, and saying, stay this stay of the FDA's rule because we will be irreparably harmed. It's not the FDA that will be irreparably harmed. It's us, Danco.
And if you're going to get emergency relief, you have to show imminent and irreparable harm. And that's essential for Danco. I do feel sorry for everyone listening to us talk about the stay of the stay of the stay.
I wish they had different Justice Alito used the word suspension for what the Fifth Circuit did below, which is very helpful when you're reading the opinion, but it was actually a stay. Is what it was. So
these make-up words to.
Yeah, because it gets very confusing very fast as to what's going on. But
even more confusing, but just people might be wondering, okay, so it's Danco versus Louisiana. Where is the FDA in this? Because they are part of the case.
Yeah.
The FDA has no position on this issue. So they said, we did a bad job. We didn't consider our REMS properly. And we don't know if you should stay the stay or not. We have no position on this. So that's why
so it's only Danco and
about
Louisiana that are left at this stage. We don't know if the FDA is going to jump back in on a direct appeal. We don't know that yet. But for right now, the answer is the FDA is not part of it. But circling back to that question of imminent and irreparable harm, I want to talk just briefly at the end about this one-page dissent from Justice Thomas, because Justice Thomas is going to tell us how he feels about everything. But this one I thought was particularly interesting because he raises something that I don't think has been brought up to this point, which is the Comstock Act, which prohibits the delivery of abortion pills through the mail.
Yep.
So Justice Thomas points to this not because he's saying on the merits Danco is going to lose, because that's not really how this is going to work. Even feasibly, that's not how this could work. But what he's saying is, Danco, you can't be irreparably harmed because what you're doing by shipping drugs through the mail, these abortion drugs through the mail, is illegal. And we're not going to say that your ability to continue doing criminal action is imminent and irreparable harm. I like that logic. I think it's interesting, if nothing else.
Yeah.
What do you guys think?
I think anytime that you can make a salient legal argument in 3 paragraphs, I think you're doing a good job.
You've done something right.
Yeah. So he just goes through and says, under the Comstock Act, let me find the exact language. It makes it a felony to use any express company or other common carrier or interactive computer service to ship any drug designed, adapted, or intended for producing abortion. that makes it illegal federally to ship, like especially across state lines. And so that's what's happening here. And so he's like, if they're doing this, then they're violating federal law and committing a felony. So if they're making money from that, they actually should have to give back that money. They shouldn't be able to claim that they're losing money from it would be like a drug trafficker, like an illegal, like a narcotic trafficker, saying, well, your law prevents me from importing narcotics into your state, and so I'm suing you for damages because I'm not making as much money. It's the same logic here. Now, whether or not you think the Comstock Act is good policy or anything else, it very clearly makes it illegal to do what Danco's doing. So he's like, you don't get to just get your money, sue, because you're doing something that's felonious.
Right. That would be like saying, court, I'm irreparably harmed because I can't sell my cocaine in another state. It's like, but okay. Right. No,
yeah.
that goes to irreparability of harm.
And again, that's because if you're going to go outside the regular order and seek an emergency stay, you have to show that in the absence of a stay, you'll be irreparably harmed in some way. And his argument is like, well, it's already illegal under a different federal law that you don't challenge. And therefore, you're not irreparably harmed because you don't have a right to just break this other federal law, the Comstock Act. And so Justice Thomas, my general rule is like when he has a really short opinion, that's usually the best ones. It's like a page long. I'm like, this one's going to be good. But I think what comes out of all of this is, and I hope it comes across to the folks that are listening to us, these sorts of things are more complicated than you imagine. Right? You have, who has standing and how does standing work and what are the implications if we rule that they have standing. And then at the same time, you're like, oh, well, there's clearly a legal violation and someone's getting injured by that legal violation. So shouldn't someone be able to do something? And maybe Congress needs to do its job. And they're complicated things that are being decided by the court on a really quick turnaround. I don't know if anyone looked like how quickly from the time that this hit the Supreme Court to when this opinion came out is really fast. 2 weeks.
Mm-hmm. It was a quick turnaround.
Yeah.
And like, I think it's when the media is reporting this. So I just want to give the score real quick if I can stutter my way into that. So the media is reporting that this was a 7-2 decision, but we actually don't know.
That is an important point. We don't know what the votes are. We know that at least 5 voted.
So, we know five justices or more.
But we don't know who.
And we don't know which ones, except we know it wasn't Justice Thomas or Justice Alito because they dissented. But 5 justices or more voted to put the stay in place. And we don't. And so what happened with the effect of all this, of the stay, is that the current regulatory process is back in force. The new REMS, the 2023 REMS, which are the lower restrictions, are back in place while the case is pending. So we don't know ultimately what's going to happen, but the Supreme Court is saying until we grant review or decide not to grant review in this case, the old regulatory process from 2023, or the new regulatory process from 2023 is back in force.
And once again, because we've hammered this now so many times, this is the shadow docket, the interim docket. This is something that is coming up to the Supreme Court on an emergency basis, and it will come back. Yep. There will be a part 2 to this story. This is just a prologue. And for right now, the answer is that the 2023 rule is in place, but we'll see where we end up landing at the end of the day.
Oh, I mean, the FDA could change its rules and then moot the case, and then maybe it doesn't come back. It'll have to go all the way back to the district court for a new challenge.
That's true. That's true.
Which the FDA did say that it's working on new rules. That's part of the reason it took no part in the stay process here, is that it's working on new rules. Now, frequently government agencies say to litigants, perhaps us, that they are working.
Has this happened to us recently, Nathan? In multiple cases?
I'll just stay focused on this one. They'll say that we're working on a new rule or something else in order to pause litigation and kind of delays the action a little bit.
And it always becomes a problem when there's a turnover in administration. And of course, we've got 2.5-ish years left in this one, but that's not real long in the world of rulemaking. So I don't know. Who knows what's going to happen? And that's how we end most of these podcasts. So, anyway, if you have enjoyed our conversation today, please subscribe to our channel and leave us a review. Thanks. Bye.